You are welcome to yet another episode of HN What's Your Say? The #1 listening show where we discuss real issues with real people like you. We are still featuring R. Kelly. Real name Robert Sylvester Kelly. Also known as the R&B King. We cannot deny there was plenty drama at the New York appeal hearing as the state attorney fidgeted with words explaining the decisions of the trial judge Ann Donnelly at the Brooklyn federal court together with her jury of 12. This is the team that did a good job prejudicing R. Kelly during the trial phase and causing him the misery he clearly doesn't deserve. It's on book that many of these selected jurors were loyal followers and consumers of the toxic Surviving R. Kelly docuseries, which was purposely produced to sell the narrative that Kelly was a very bad person and a danger to society, which is not necessarily true. Many people around the world who have been following the story closely now know that R. Kelly was in fact not proven guilty for most of the charges levied against him, and that is to say in particular, the RICO, Mann Act and forced labor charges which his attorney Jennifer Bonjean is gladly battling in the appeal court. Asked to respond to Bonjean's submission, which was so informative and revealing of the fact that R. Kelly was overcharged, the state attorney began by driving straight into yet another defamation and smear campaign that was not so welcome by the appeal judges, who were quick to intercept it with real questions. It sounded as though the appeal judge was saying, wait, these are the issues you ought to address, and we are speaking of whether there was in fact sufficient evidence to charge the R&B King with RICO or not. The judges also wanted to know whether the Mann Act charges were appropriate, considering there is no evidence that the women allegedly exposed to an STD did not have prior consent from defendant. And also important to one of the judges was the issue of undeserved restitutions, which should not have applied, considering the public health laws in the state that was charged were repealed and are no longer in operation. The highlight of the day, however, was when the appeal judge who demanded that the state attorney explain how the forced labor charges ended up on the indictment asked tough questions that saw the state attorney reveal what was supposed to remain a secret between the government and the trial judge. The appeal judges realized that the state attorney was always beating around the bush and not really explaining how these charges came about, and how the guilty verdicts followed. Instead of explaining the charges and backing them up with evidence, she was busy mudslinging and mentioning how R. Kelly did this and R. Kelly did that. Listening to what she had to say, it was possible to mistake her for another accuser responding to questions in a cross-examination during trial. It is at that level that accusers usually do their best to tarnish the defendant and throw as much dirt as they possibly can without reason for the jurors to sort out what makes sense and what doesn't. For a state attorney to try and do this at appeal level, it's so absurd. Bonjean's argument against the forced labor charges dwells on the fact that one cannot claim forced labor based on one-time events. Forced labor is indeed a pattern of events and not something that can be derived out of a one-time experience, even if it involves someone forcing another person to do something. Rape, for example, is rape and not necessarily forced labor. But when you look at the claims of forced labor for Geronda, for example, the government was typically describing a one-time event where R. Kelly allegedly got angry with her because he felt disrespected, and she claims he then forced her to perform oral sex on him. Whether this happened because R. Kelly was angry with her or not, it still remains a one-time event that cannot justify the forced labor charges, and these, according to his attorney, should be dismissed without prejudice. And when it comes to the same charges in relation to Faith Rogers, who even during trial was open enough to remind the court that she is not a victim of R. Kelly but gladly made her choices as an adult woman. The government alleges that a woman who had been in an intimate relationship with R. Kelly, enjoying casual sex with him frequently in different parts of the country, quickly became a victim of forced labor, because one afternoon when she had come to him for the usual, she found a gun lying on the table which allegedly unnerved her. Finding a gun on the table this one time does not quickly erase the fact that she had come to engage in the usual activity they both enjoyed, and the gun's presence being a one-time event does not qualify this as forced labor. Besides, record has it that even after this allegedly unnerving experience, Faith Rogers continued to see R. Kelly. When asked to explain the forced labor charges, however, the state attorney meandered a lot, and this caused the appeal judges to demand that she proves these charges, asking where is the forced labor because they clearly didn't see it. Grilled and out of options, like a drowning man would catch on a straw, The state attorney sought refuge in reminding the court how R. Kelly allegedly made his girlfriends to write false letters and to work on websites, all claims the government can't even prove. At this point the government had conceded defeat and surely, the forced labor charges are bound to be dropped. It's only a matter of time, and once the judges have deliberated, many believe that the first charges to be dismissed without questions will be those related to the alleged forced labor. According to Peter Keene, I did listen to the entire New York appeal audio, and in fact when the appeal judge asked where's the labor, he sounded frustrated trying to imagine things that clearly didn't exist. The state attorney's strategy of beating around the bush instead of explaining the trial verdict was not working, and it was instead beginning to annoy the entire panel. The government ought to know that the justice system is airtight, and whatever is illegally or carelessly passed at trial level can be sieved out at appeal level. In fact, the appeal judges also ought to be as accurate and keen as possible, because if they ignore the RICO appeal demands by Bonjean, like she said, the Supreme Court will listen. While it's already weird that our Constitution has chosen to officially look at sex as a job, technically encouraging prostitution among our youngsters, government's attempts to twist the labor law and assume forced labor from one-time sexual encounters is a misinterpretation of the statute. According to Saloise, I have been saying this for years now. It's always people of color that get hit with such BS concocted charges. The others may be equally prosecuted, but they never get hit by such twisted charges as these people of color have had to deal with. The justice and government systems are corrupt and very crooked, especially when it comes to dealing with people of color. Just when will the system and these minions start to be held accountable for these wrongdoings? If you wish to take part in a live interview on this channel discussing any of these topics, let us know by emailing us on sashahnnewsroom@gmail.com for scheduling. That is all we had for you today on HN What's Your Say? To keep updated whenever we post a new video, subscribe to this channel now. Also remember to hit the bell icon and enable notifications. And feel free to share your opinions with us in the comment section below, and let us know if you would like us to publish your views in our next release. We value all our subscribers' opinions.